right, good afternoon, everybody. Let's see. There we go. Oh, that's me. You know what I look like. All right, so who knows that Taylor Swift is coming to New Orleans this weekend? It is the biggest news, and I am still waiting for tickets to fall in my lap. So if anybody has a lead, I should have taken somebody up on the offer months ago, but now it feels kind of desperate to try and get Taylor Swift tickets. All right, so who here likes to cook? Anybody? All right, we're going to be talking a little bit about the Gumbo of Law. And I love to cook, so it was easy for me to say yes to be here with you all to kind of bring together the concept of cooking and gumbo and the law. So I'm just wondering if this has ever happened to you, if you've ever thought about cooking something that you saw on TikTok or Instagram. Anybody see those awesome, really short videos and you think like, I could do that. That's easy. I have those ingredients. I'll do that for my book club next week. And then the day comes and you're late leaving from work and you have to stop and get the wine and you get home and you realize you don't have the ingredients. You're scrambling, you're making some substitutions, maybe you don't have the right cookware, and it's a flop. And your friends show up and you're like, we can A, serve the flop with copious amounts of wine. I've done that before. Call Papa John's for pizza. Papa John's isn't my favorite. Or, perhaps call the French restaurant around the way, order some crepes, pay way too much money. But no matter what, you're kind of bummed that you've had this dish in mind, thought it was going to work out, thought you had a plan, and it looks more like this. So, in my experience, that's not all that different from being proactive at work. In HR, this is how it's supposed to go. You want to feel confident, you want to feel in command, you want to do the right thing for your employees and for the business. You want to be viewed as a strategic partner to the business, not just the no person, not just the you can't do that person or ruining everybody's fun, and I've heard that so many times. You want to be proactive and strategic, and you want to solve problems before they arise. But perhaps like your Instagram meal, it doesn't always go that way. So, let's get real. Every time you think you're going to be proactive, you've got a great plan to do an audit or do some training, but then all of a sudden you get something else that pops up, you've got fires to put out, and it's just not as easy as maybe the best laid plans before. Who here has ever had an employee out on leave due to a medical condition for a disability? How time-consuming is it when you give the employee what you need to hear from the doctor to determine an accommodation and they don't respond? Kind of frustrating. And the business leaders are pressuring you because they're like, we need that person back to work or we need to refill their job. And you're like, there's this thing called the interactive process and I have to do it. And you're telling them they have to engage in the process, they're ready to move on, and you're spending tons of time saying, please send me the paperwork, we need to evaluate this. That's just one tiny example of all the things I help clients with every day that end up being the fires that take so much time away from the proactive things that HR could be doing to advance important strategic goals. Training sometimes falls by the wayside. Then you have a sexual harassment allegation at one of your sites, and you're like, oh man, that training really would have helped with my defense of my case, because now I don't have much of an affirmative defense because nobody was trained on where to bring their complaint. So I know how it feels. It feels impossible to keep up and sometimes a bit overwhelming. And I think you all heard me say this yesterday. I used to be the guy on the left, kind of frustrated with the way the game was going, with the problems that arose in my client's workplace when I would get an EEOC charge to respond to or a lawsuit, and I would get all the information. I'm like, oh man, really could be doing better, could have done better, perhaps with the training or other things that might have meant that the issue might not have arisen at all. So I decided to get in the game, and for me, that meant leaving a gigantic law firm and going out on my own and doing things more proactive with clients to try and avoid those types of issues. It's much easier to be a Monday morning quarterback and criticize people. It's a lot harder day to day, as I'm sure you all know, when you're wringing your hands about a particular decision. Do we have enough to terminate? Should I send them back for more documentation? It would be easier, to just move on, but you've got all of these processes to follow, and often the process is more important than the outcome, right? Doing the interactive process is often more important than whether or not you grant the person an accommodation or not. So that's why I pivoted my career. I left big law and started my own firm to proactively assist clients. But let's also talk about a little bit more about what the real problem is. One of the hardest things we're dealing with is being proactive is dealing with the patchwork of federal, state, and even local laws. How many of you operate in more than 2 states? More than 8 states? More than 20 states? More than 30 states? We still have hands up. That's incredible. That's tough, right? I mean, you're, again, federal, state, local laws. And sometimes I think, like, wouldn't it be great to just have more federal laws? Now, nobody likes federal laws, and I'm not one of those proponents necessarily, but when we're all operating multi-state, it would be a lot easier if we took a step back from a patchwork of regulations and just had some uniform regulations. So I'm sure you're all familiar with these laws here. We've got the FLSA that sets minimum wage at $7.25. How many of you operate in states where the minimum wage is higher than $7.25? Right. And varying, and sometimes varying by industry and varying by overtime and all those types of things. FMLA, more than 50 employees, unpaid 12 weeks. How many of you operate in states where, I already see the hands, where you either have paid leave or you have a different amount of leave or you have sick time, all of those things on top of this. Title VII, I'm sure, applies to every single one of us in the room. How many of you have additional discrimination obligations under state or local law that you know of? Right. ADEA, protecting your older workers, and of course your accommodations, which in some places are more expansive, like for example, perhaps in some states with medical marijuana. So when we talk about these discrimination statutes that exceed federal law, here's a few: family responsibilities in Alaska and DC, political affiliations, protection for domestic violence victims, which actually came up recently when I was talking to a colleague about how to protect somebody with a domestic violence issue, but they were not in a state that had domestic violence protections. Medical marijuana, as we've already said. Height and weight. How many of you operate in a state with height and weight? Okay, I mean, that is tough. I once represented a very tall doctor, and he was having trouble getting he was a GI, and he just needed to scope people. And by represented, I mean he was my friend. But he's like, I'm really tall. Like, I just need them to give me a taller table so I can scope people because I'm bending over all day doing these scopes. And I had to go back and forth with his employer, the hospital system here, to say, give this tall guy a bigger bed. Not because you're legally required, because of course here you're not, but it might turn into a disability. And then if it turns into a disability, it's a whole other story. But you know, you're dealing with all of these things all of the time, so I'm pretty sure you know what I'm talking about even better than I do. But here's one example, last paycheck rule. So I had a client call last week, week before, with an employee who works for a maritime company, and the employee works on boats. Deckhand, I think, or pilot, one of the two. Anyway, so he lives in Texas. He works on a boat. The boat goes through the inland waterways all over the country. And the employer's in Louisiana. And the employee emails, because you know employees are really good at sort of knowing their rights. And he says, you are required to pay me my last paycheck in 3 days, because he was in Texas. Does anybody know whether that's right under Texas law? It's not right. How many days do you have to pay in Texas? 6. 6 if you're terminated. Next regular pay period if you quit. So he wasn't right, but it sparked this issue with the client because anybody know what it is in Louisiana? How many of you operate in Louisiana? What? Anybody know what it is? It's 15 days in Louisiana or the next regular pay period, whichever is sooner. So why does this matter, right? I mean, we spent so much time thinking about which pay period do we have to go with. I said, why don't you just pay them with the faster pay period? Like, that just seems easier to me. But they're like really stubborn and no, we're not going to do that. But it matters because all of a sudden, at least in Louisiana, if you don't pay people timely, vacation, last paycheck, everything they're owed, then you are subject to penalties and attorney's fees. And some of the biggest cases, some of the cases that I've handled in Louisiana that start out small, we're talking $200, $300, $500 in wages, or usually vacation has been hotly litigated here in Louisiana. turn into the largest amount of damages. You get a demand for $25,000 over something that was $500. So even the smallest things like these last paycheck rules can really give you fits. And then there's sort of the elephant in the room. We talked a bit about it yesterday. You've got the election coming up. And in addition to the stress that that might be causing in the office, it also is going to have a huge impact on how you respond to regulations and what's going to be on the horizon. So one administration will roll out regulations aimed at protecting workers, and then the next administration might come in and try and roll back those very same regulations. And that all involves our agencies, because then our agencies, under the different administrations, are making their own rules. And not only they're making, then often businesses go and challenge those rules. And then in the meantime, the courts have to weigh in because the courts are the ones who will ultimately decide whether the agencies have exceeded their authority. So you've got all of these levels at play in your workplace: state, local, federal laws, obviously the election, the agencies, and then even the courts. Is anybody following the FTC non-compete ban? Do a lot of you have employees on non-competes? Yeah? Or how many of you actually like non-competes for employees? No? I see some shaking heads, no. So obviously non-compete laws have been around for a long time. They have generally been state laws that provide that businesses who have a legitimate business interest, usually proprietary information, will be able to put their employees on a non-compete so that they can't leave the workplace and then take customer lists and other proprietary information and immediately either start their own business or go to a competitor. That's a legitimate business interest. However, as we know, sometimes our business and operations units get a little overzealous. Employers have started using non-competes to hand-tie rank-and-file employees, including, at all different levels, people who have absolutely no proprietary information. It just seems like a nice way to get them to stay. I would say it's not a great way to try and get people to stay. And this issue has actually come up in Louisiana recently on an industry-specific level. Here in Louisiana, we have a non-compete law, and you can have a non-compete as long as you list the parishes, those are our counties, throughout the state where you do operations. Well, our largest health system wants to keep their doctors. They invest a lot in their doctors, but then they put them on a non-compete because they operate statewide, a non-compete that bans them from working for 2 years anywhere in the state. And that prevents them from being able to deliver health care, which impacts patients. And I personally have been in the situation of having doctors move to other states because they don't want to stay here, and they won't be able to, if they don't want to keep their current job, then they basically have to leave the state. So that's sort of the balance between the legitimate interest in a non-compete versus perhaps some that might be too restrictive. And non-competes were certainly on President Biden's agenda. That rolled out first with this FTC non-compete ban in January 2023, basically prohibiting non-compete agreements, which as an agency action is pretty dramatic. So of course the business community responded with multiple lawsuits. And when you're bringing those lawsuits, and you have to think about where's the best place to bring my lawsuit? Employee-friendly, business, pro-business. So Texas happens to be the first state that got to this result, which is the Northern District of Texas ruled that the non-compete ban was improper, that it was an overreaching agency action. And so not only did that plaintiff not have to comply with the non-compete ban, but has a national injunction against implementing this non-compete ban. So everybody, many of my clients are sitting around waiting, and they're like, okay, now we don't have to do it. Oh, but they can appeal to the Fifth Circuit, and then they might appeal to the Supreme Court. So there is not a lot of settlement around some of these. This is just one agency action that I think is really interesting right now, but this applies across all types of decisions. Title IX, for example, in higher education, there was one direction under President Trump and other directions before that, but then under President Biden, a different direction. And just as Title IX workers are trying to implement the new rules, then there are all of these challenges, and people are left trying to figure out what to do. And so what ends up happening when federal law isn't clear or taking too long or is not settled, states start enacting more local regulations. So, you've got states who are putting more non-compete issues on the agenda, and then also you've got the National Labor Relations Board, who came out months ago and said, we think that non-competes are a violation of the NLRA because they restrict employees from moving to a different company, and therefore that's sort of a per se violation for non-managerial employees, that there's no legitimate reason to make employees stay. And so then just a week and a half ago, 2 weeks ago, after the FTC ban got knocked down, the NLRB chairman, general counsel, came out and said, well, actually, we really think that these are not enforceable, and we're going to start instituting fines and other penalties for businesses who try and enforce non-competes. So then as businesses continue to hire people or even let them go, they're saying, can I put non-competes in these new agreements? Can I not? I'm letting somebody go. Can I tell them they have to abide by their non-compete? Do I need to pull back all of these non-competes because the NLRB believes that all of them are invalid per se, and then even having them is improper. And of course, in California, you can't have them anymore, and you had to send out notices to bring them back. So it's just incredibly complex, and it actually would be easier if there was a federal law that addressed this. But this is the push and pull that I'm sure you are all well aware of. So we're here today about the gumbo, because I've got the secret recipe, right? I've got the magic recipe that you've never heard from anybody else on stage to tell you how to deal with these problems. Well, I hate to disappoint you. You can imagine that I don't have the secret recipe to fix all these problems because it's impossible, right? There's no foolproof way to fix these compliance problems in your workplace without putting in the type of work that I know you're putting in every single day. So, c'est la vie, that's it. I guess we're all stuck. You might as well finish now and go get ready for the D-Day Museum because we don't have a solution. However, I do have some ingredients. So, I've developed 5 ingredients for managing workplace compliance and risk. It goes with the word human. We're not going to go through all of them, but H is for help. HR is here to help employees, but HR needs help themselves. Yesterday when I said, take a breath, because you're not going to tackle all of this immediately. You have too much going on. You have to figure out what's the most important. But I think in a lot of ways, HR's got to put the oxygen mask on first, just like they tell you to do on an airplane, because if you can't tackle it all at one time, you need to sort of take a breath and figure out what to do next. Understand the legal landscape. We talked a little bit about that earlier. We could talk about that all day, but we won't talk about it today. Managing proactively, assessing risk and delegating, and noting lessons learned. Those are the 3 ingredients that we're going to talk about. So managing proactively. Like I said, we all want to be proactive. It's just not always happening. We want to check items off our to-do list. Sometimes that means grabbing a well-meaning template. How many of you have ever used a template or asked a colleague or somebody in your industry for a template? How many of you have had that come back to bite you in the butt because the template wasn't worth the paper it was written on or the electronic document that it was in? I had a client ask me for a template recently for an independent contractor agreement. I said, it's not that easy. First, you have to determine whether they are an independent contractor correctly, and then what is the right way to set it up for these folks. And it was a staffing company, so they were going to be rolling this out. I resist templates if you can, but they can be a great starting point. That is my caution on the templates, but it's certainly something that we all could use to make our lives a little bit easier. So, in being proactive, what are some of the things that we can do? You can obviously have projects like audits, which is like, audits are horrible, right? Like, we're going to audit our positions, we're going to audit our pay. All of those things are a pain, and they usually, when it comes to the fire, sometimes the fire looks more attractive than the audit. Am I wrong? Like, I would rather deal with the employee complaint or the request for an accommodation, whatever it may be, so I don't have to do the long-term, dreadful policy review or handbook update. People spend so much time on handbook updates because I think just opening the document takes the first 2 hours. So, when's the last time any of you audited your positions? right? You're supposed to audit your positions, determine whether people are exempt or non-exempt. Then you got to go to the job descriptions, make sure they align. All of that takes a ton of time. I can't tell you how many people, now I do work in Louisiana, and we can be a little bit backwards, but I cannot tell you how many businesses will tell me, like, we're salaried, so we're good. Everybody's exempt because they're salaried. Like, you have to deliver the really bad news that just because you're on a salary doesn't make you exempt, right? And I'm sure everybody in this room knows all about the duties tests that then rely a lot on the job descriptions that also rely on what you're actually doing and can make that audit process incredibly difficult. Training, another great proactive thing to do. The manager who's properly trained, if you take on that proactive project, the manager who's trained the way they should be might not ask the employee about what medications they're on, might not tell the employee to stop taking their medications. There was a great case out of the North Shore in New Orleans about, I think it was a car dealership, and the manager, I don't know how it came up, but the woman disclosed that she was on ADD medicine. He said, you really shouldn't be taking that. So he told her to stop taking her ADD medicine. So thereafter, she started acting a little bit differently because she was not on her ADD medicines. So he's like, you're acting weird, so I'm going to send you out for a drug test. So then the drug test pops back with a flag, right? And before he waits to see whether or not she's on any medicines that might then clear her, he fires her. So as you can imagine, the EEOC was all over it. And the worst case scenario, right, is the EEOC coming after you. Individual employees bring claims, bring charges, but the worst cases I've seen are the ones where the EEOC versus company, not plaintiff versus company. And they've got certain hit lists, they've got their priorities. It's always great to read their reports where they talk about what their priorities are, because you can know that, okay, well, we really got to be careful with our pregnant workers. That's a hot issue right now. Disability is a hot issue right now. Using AI in making hiring decisions is a big issue right now, so that you can figure out what you need to be doing. But in the case with that manager, had he perhaps been trained, or maybe a little more couth or polite, might have just avoided that altogether when they ultimately were, I think they settled it for a couple $100,000. So hopefully training is less painful and less expensive. So we want to manage risk proactively, and we'll talk a little bit about how you can actually get to the proactive things that you need to do before the agency comes to you, or before the plaintiff lawyers send you a demand letter, or before the EEOC has you on their target. I was talking to somebody about this yesterday. When you have an agency interested in you and they're showing up for a wage and hour audit, and you're delighted that all of your records are the way that they should be and you've been paying people appropriately, but they're there for a reason, right? They need to find something, and they will find something. They will find something tiny so they can justify their job. So not only do you have to do it all correctly, deeply substantively, but even on some really small, tacky things, you might still have agencies bugging you. So better to not ever be on their radar if you can avoid it. So I want to talk about another proactive tool that I think is often overlooked, and that is workplace investigations. How many of you are responsible for workplace investigations? So, they're not that fun. I was talking to somebody earlier, like on my end, on the outside, it's usually fairly interesting because I get to know a business, I get to hear about what they do, I get to listen to employees about their jobs and also their complaints. But internally, I have a lot of clients with internal investigations teams, and they're tired. And they're tired of dealing with perhaps some of the same people or the same issues over and over again. But it's a really great proactive tool to make sure that you can identify what the problems are, and it is your opportunity to make sure that people don't go to the EEOC or they don't file a lawsuit, or if you uncover some sort of pay practice through a complaint, that you might be able to have the opportunity to fix it. So I do think it's a sometimes overlooked proactive tool. So there's like investigations with a big I and investigations with a little I. Investigations with a little I are small things, small conflicts, performance issues, some policy violations. I've seen people treat investigations with a little I like big time investigations with a big I, like it's the end of the world, or vice versa. Things that should be given a lot of attention are sometimes treated like they're not worth that level of attention. But it's still important to make sure that you're documenting. Of course, the most important thing in HR is documentation. Documenting your investigations with a little I. Then you've got your investigations with a big I. The more serious issues that involve legal or regulatory, formal processes and documentation are usually required, and you want to put a little more thought into who's doing the investigation, how your processes, and how you can protect the company, assuming if you believe that it might go further, if you believe somebody might bring a lawsuit, how can you make sure that your investigation is as defensible as possible, particularly in high-risk situations. So they require more thoroughness, attention to detail, and sometimes collaboration with either in-house lawyers or outside lawyers. So then there's some complex investigation issues just to put on your radar, because I deal with them every day, and I think people aren't always thinking as critically about some of these as they should. Attorney-client privilege is a big one. Often when you use somebody on the outside who is a lawyer and generally has to be a lawyer under state statutes, you want that attorney-client privilege, but you also might want to waive that attorney-client privilege. So you want to start by thinking about, do I want this investigation to be privileged, and if so, who could and should conduct it, inside, outside, and have the opportunity to keep it privileged, and perhaps have the decision later as to whether or not you want to waive that privilege. Certainly the pros and cons of internal versus external. Internal people know what they're doing, they know the players, they know the policies, they can get it done, often get to it more quickly, but they often know the policies and know the players and know too much about the people involved. I want to bring your attention to the preponderance of evidence standard, because I know for a long time in investigations you're like, well, it's he said, she said, he said, they said, so I can't really come to a conclusion. And after doing this for a really long time and being part of groups like the Association of Workplace Investigators, you have to come to a conclusion. It's your job. And so in deciding how do I, because sometimes it's really difficult, that standard 50% plus a feather, 50% 0.1, can really help you to say, okay, I don't have to believe them completely. I might still have some doubts in my mind, but here's that 50% level. And also those credibility pieces around who has the most incentive to lie in the situation, who had the greatest access to be able to observe what was going on, and then weigh the credibility of the witnesses. And I've found that that can provide me a lot of clarity when trying to reach conclusions. Fact findings based on scope. So first, that presupposes that you have a really well-defined scope, but a well-defined scope is really important so that you know what you're investigating, and as people bring up other complaints or other issues, you're like, oh, okay, well, that's not my scope. And you can go back and decide if it should be added to your scope, but at least you can kind of keep some control. I mean, who's ever had an investigation that kind of spun out of control? I think I had an investigation that had 35 witnesses, was the most I've ever had, but it was significant in scope. And then report writing. I mean, report writing is a skill, and know that 2 years later, if there is a challenge, if you do go to court, if the person who did the investigation has to be on the stand, the report is your best evidence of what you did or didn't do, including information on your process, who you did interview. I'm currently writing an investigation report, and I'm writing about why I didn't interview certain people, so kind of proving a negative sometimes. But writing a well-defensible report is really important, and it's something that HR should be trained on if HR is doing it internally. And then finally, investigations is a crisis management tool. I think it's a great thing to remember, because I think that often companies forget that you can do an investigation kind of any time. Maybe you shouldn't always do it, but that if there are things that come up and maybe it doesn't fit the box of what you normally investigate, there are opportunities to do investigations to set the record straight. So as I'm sure you're all aware, it takes years to get to court. It takes months to get to the EEOC, and then from there, employees have 90 days to file their lawsuit, and then if the case continues, it might be years before you get to a jury, but bad media coverage and social media allegations are instant. And often in the media, I see people saying, like, the company strongly denies those allegations, and we will prove that at the appropriate time. That's not really what people want to hear on social media. That's not how quickly the pace of our world works anymore. So the more you can avoid trial by media, the best way to do that is to say, we actually hired somebody who is independent, or we use someone who is independent to look into these allegations, and here are the facts that we found. Often when it comes to that level where it's in the media, people's reputations and their careers are on the line, and it's really important not just to defend the company, but to make sure that people are treated fairly on both sides. All right. Before I get to assess risk and delegate, I'm going to talk about, I think, the most important risk avoidance tool for HR, and I'd be curious if you all agree. Who's ever heard the term happy wife, happy life? I mean, I think it's not a bad saying, and I could not figure out a good rhyming saying that goes with this, but I think that there's something to be said for happy employees, fewer claims. It's not so catchy, but it's totally true. I work with clients where their employees are thrilled with where they work. They feel like they're treated fairly. They feel like they're compensated fairly. It's not even on their radar to file a claim against the company or even make a complaint. They know that if their coworker says something a little bit offhand, they might assume good intentions. But once employees' relationship with the company is frayed, there's something that's happened to make them not trust their manager or the company. Maybe it's finding out that somebody makes more than them. Maybe it's not feeling like their performance review was fair in light of the other circumstance. Maybe they didn't get the raise that they had been promised. Whatever it is, that is when employees start to think about claims. The number of times I defended cases, there was an older lady that worked at a casino, and she was a dealer, and she got fired for cheating with somebody. And we had to go look at the videos in the video surveillance room, which was really cool. But her claim was about age. And she said, like, they call me old granny all the time or something. And you go to talk to all the witnesses, and they're like, she called herself old granny all the time, you know? And when she got fired, then she was like, what can I think of to put together this claim? And I've seen it with comments, you know, where people laugh and think it's funny. Now we have to be aware that sometimes people laugh and think it's funny and they are offended. But sometimes, again, when people are afraid with the organization, they are looking for something to come after the company for. Perhaps they've been let go and they feel like they've been a significant contributor. Perhaps they've been there for a long time and the company lets them go with no warning, no severance, no opportunity to be heard, no exit interview. Like, you know what? I'm going to get them, and I know where the skeletons are buried. They do. You know, that consideration of whether or not to give a severance, I've had that conversation so many times. Different companies feel different ways. Some do it all the time. Some are adamantly against it, except in very limited circumstances. But it's always something to consider because it's almost a respect on the way out of the door. I often actually see the severances paid to the bad actors more than the good actors, because the good actors are the ones who you're letting go. You know, perhaps it's a reduction, whatever it may be, and they don't have a claim, and so you're going to let them go with no severance. But the person who is the bad actor, who you know is already contentious, that's the one who you give the severance to, and it seems a little unfair. So I just think thinking through this idea that happy employees don't file claims goes well with a lot of the themes we've heard in this conference this week. There's only so much you can do. I think employee claims are unfortunately a cost of doing business. But I will say in the clients' businesses where people are happy and they feel respected, they face far fewer challenges, far fewer complaints, and all of that helps HR have less headaches and less fires to put out. So assess risk and delegate. How do we allocate the limited resources? Because it's pretty easy to say, I'd love to do all of those things, but I don't have the time and I'm putting out the fires. So that's the key ingredient, is prioritization. I'm going to talk a little bit about how you might evaluate the risk level. So you could do this formally on a grid, you could do it informally in meetings, but you want to talk about what's the severity of the impact. Could there be a huge financial loss if this particular issue were uncovered or if a lawyer got a hold of it? What kind of regulatory problems could you have if the agency showed up unannounced? What kind of employee turnover will you have if you don't address it? And then looking at the likelihood of occurrence. Sometimes, you know, it could be a significant risk, but of course it's not very likely to occur, and maybe you can put that on the back burner. That's a good choice to make if you've made a reasoned decision to put it lower on the risk level. So in regulatory and legal compliance, obviously those things are going to be the most important to try to address. So high-risk items are the ones that need immediate action, where there's serious compliance violations, safety risks, and legal matters should be a top priority. And I will say, I don't hear a lot of lawyers saying this because lawyers are usually trying to tell you what you have to do to follow the letter of the law in every circumstances. But we all know that you can't do that, that sometimes there are two competing interests that are very important. And one that I see a lot in my practice is safety versus discrimination, unfortunately. So I've had the pleasure of representing a nuclear facility, which is pretty interesting for a site visit. And they have a lot of safety regulations. They are regulated by the Nuclear Regulatory Commission. And safety is really important. And because of that, often they do get a pass on certain things because they can rely on those regulations. But there are times when, say you're dealing with an accommodation request and somebody can't physically perform quite up to the level that you need them to perform. And perhaps they could use an accommodation, you're aware that they need an accommodation, but the people on the safety side are saying, we cannot take the risk when we are in a nuclear regulatory facility that this security officer will not be able to run to the right control, do the right things. Now, low likelihood, right? Knock on wood, low likelihood of a nuclear regulatory incident, but high impact if it goes wrong. And so I often see people say, safety is more important, we're gonna run the risk on this other piece. And from a practical legal standpoint, I'll say this. Think about like a truck driver. There have been several EEOC cases recently where truck drivers might have disabilities like hearing impairments. And the company says, we don't think that you're safe driving. And sometimes there are accommodations that are and should be given, and I think the EEOC has proved that in some pretty big ways recently monetarily. But again, like safe space here, sometimes you make a real decision to say the safety piece of somebody driving an 18-wheeler today is going to be more important, perhaps. Again, I know we have a lot of disability advocates here, but sometimes that is the choice, that safety with an 18-wheeler is going to trump perhaps an accommodation needed by a driver. And from the legal piece, if the driver gets into a wreck, causes a huge interstate jam, kills a number of people, you can't even count the zeros on that verdict. And the ways in which somebody's gonna say, you let that guy drive an 18-wheeler? Same thing with drug testing or asking impermissible questions, right? We really can't ask those impermissible questions, but I'm gonna do it because I really can't have the 18-wheeler pileup. Whereas, practically speaking, on the discrimination side, Title VII has caps on liability. So Walmart, always getting hit with all of the cases, every time you see a headline, it's like, Walmart hit $100 million. And you're like, but everybody who knows like $300,000 is the cap. So they look like terrible employers, and whatever they did is often not good. However, it's going to be reduced to $300,000. That's another federal law that could probably use a bit of a bump, because I don't know that $300,000 is a deterrent to organizations to not engage in some bad behavior when they are making the kind of cost-benefit analysis that I just described, safety or some other business purpose versus following the law the way that you really should. So, you want to involve your experts in all these decisions. While it's good to weigh those things, you'd want to really be deliberate if you are determining whether or not a high-risk item should be at the top of the list or the bottom of the list. Moderate risk. Certainly you could delegate those things to internal team members, building up and training your team so that they are capable of taking on those issues. Perhaps you do it via subject matter expertise or geographic location, lots of different ways, but knowing who your go-to people on your internal team will allow you to move some of those moderate risk items off of your to-do list. Low risk, monitor and streamline. I think sometimes the low risk things rise to the top because maybe they're the noisiest. They're like the person who's always bugging you, or the person who's making all the complaints, but the complaints really don't add up to much, and while they perhaps need to be addressed, there are these more important things. So find a way to monitor and streamline the things that really are not going to elevate your department or bring you a lot of legal risk. If it's not gonna benefit you and it's not gonna really harm you, then perhaps those are the kind of things that can be moved aside. So here's a decision matrix for you if you're sitting around thinking which items should be at the top of my to-do list. High risk, high likelihood, as you can imagine, maximum resources. And that often means spending a lot of time internally or paying people externally. because it allows you to make sure that those really important things with a high likelihood are taken care of. Moderate risk, moderate likelihood, moderate resources, as you can imagine. Internal team, staying on top of it, informal resolution, really good documentation, but at least you know where it fits in your matrix. And then finally, low risk, low likelihood, a distraction. We have so many distractions. Find the ways that you can move along the distractions. So then once you really dig in on that assessment of risk, you can delegate and think about your kitchen team, your HR team, like a kitchen brigade. Who's in the kitchen with you? Who should be responsible for what? External options. There are a lot of companies that are still handling so many things internally that if they could elevate them to somebody else, push them outside the company, there's a cost, but the savings of time and energy inside the company are sufficiently worth it. I would say that includes like tech-enabled things like payroll, or even I have a lot of clients who are moving off their leave management process because leave management takes so much time. And if you find a good vendor who can use technology where employees can track their leave, the alternative, and the clients that I've worked with, coaching every single week on, 20 cases a week, are spending so much time sending out letters, receiving letters, doing individual analyses. These companies, like the ones who do the leave management, they've got nurse case managers, they've got technology, they've got all of these things. And as the lawyer, and I've discussed with other lawyers in the room, I worry, you are responsible. So if they get it wrong, it's on you. You have to make sure that all of these vendors and providers are actually good at what they do. But I've sat through presentations on behalf of my client with leave management companies where I grill them. What about when this weird specific case happens? What about this? In particular, something that comes up with outsourced FMLA is the conversion to ADA. So is this company who's handling your FMLA going to make sure that after 12 weeks of leave under the FMLA, that there is a consideration of whether or not an accommodation is needed under the ADA? That's a really important gap that sometimes people miss. But if you're properly vetting these teams, I think they can really help take things off of your plate. So, note lessons learned. I think this is a piece that's often missed because people are ready to move on to the next fired, or even ready to move on to the next priority. There are so many things to learn with each employee relations issues. There are so many times when I conduct an investigation where out of it might not just be the separation of an employee, but looking at where were our policies, where are the gaps right now. I have a current investigation where there was a question about gifts, and the person accepted certain gifts from a vendor, and then that vendor turned out to, people had a lot of suspicions about that vendor, that because that vendor had given gifts to that person in HR, nobody trusted that. So we're going back to the gift policy. Is the gift policy up to date? Was it followed? I think in that case they had an adequate gift policy, but the person and their manager did not make sure that it was adequately followed. So sometimes it's really just a post-mortem as things happen to make sure that you're reflecting on what you've learned and instituting any changes that you might need to change based on what you've learned. It's just like a hospital, except hopefully with less life and death stakes. Sometimes it's what went well. How did we delegate? Who really rocked it? Who on the team really did a great job handling a particular type of issue? And say, wow, you really did a great job. Now you're going to be the go-to person on that kind of issue. But whatever those lessons are, make note of them so that you can bring them back into the fold. Oh wait, I wanted to go. What was I saying? PTO policies. I have a client who, and I was going to say, sometimes your post-mortem is not actually. Sometimes you move too quickly to change things based on a post-mortem. So I had a client who had unlimited PTO. How many of you have unlimited PTO? Ish? Yeah, most big companies don't have unlimited PTO because they've sort of learned over time and they're managing so many people and people take advantage. This was a small client. It's always the most well-meaning clients. They're unlimited PTO. Woman takes a week off. She had taken a lot of PTO for various reasons. Then she takes more PTO. Then on the last day of PTO, she drops a discrimination claim, a harassment claim against him, the owner of the company, and then requests medical leave based on the trauma that she had from him allegedly harassing her. So then she needs another month after that. And so he immediately says, I'm done with this PTO policy. It's going to be 5 days or nothing. And literally wants to roll it out in the midst of this negotiation of this departure. I'm like, really, you can't do that. It might even be perceived as retaliation. But sometimes the issue that you faced, the post-mortem might reveal things, but they might be unique. Sometimes maybe you don't move so quickly to upset the apple cart because of one particular issue. And I personally have seen unlimited PTO go wrong in a number of ways, and most companies kind of grow out of that for lots of different reasons. But in that case, I think it was a matter of just putting on the brakes and saying, maybe we don't need to be so quick to make such big changes for all of your other employees who have not been a problem before we really consider what the right thing to do is. So, imagine if you could work in a way that didn't feel like you were this gal putting out all the fires, that you had the pieces in place to be proactive and to address issues when they arose. You could take the time and attention that you need to make sure that you are doing all of those audits that you love, taking on those projects that really need to be done, making sure employees are trained. You would have that option if you find a way to more proactively address the issues and make sure that you know that you have team members who are in good hands. Sometimes it's we have too much and we need to hire and add people to the team. But either way, getting from the fires to the beach is what we want. Imagine you're on the beach with your significant other for their 50th birthday and the email comes in that says, well, you know, the allegation's been made against the senior VP, or here's this other really important thing. And imagine if you could just put the phone down and not immediately jump to your computer and get on the Zoom meetings because you have confidence that you have the ability to address those issues and to know the people who can handle them at least until you get back. So, hopefully now you have a bit of a plan in place. You have someone on your team trained and you can trust those steps, and hopefully that would feel really good. So now it's your turn to get in the kitchen, to manage proactively, to get together with your HR team and think about who's handling what. I think communication is something that's been talked about a lot about this week, but really understanding what everybody's interests are, what everybody's capabilities are on your team, knowing who your internal and external team are, so that you know the go-to person for the different types of things, even if it means just making a basic list of here are our resources. You know, I have clients who acquire a new business perhaps in New York, and I say, you know what, I'm not capable of handling your employment matters in New York because you have so many state-specific issues to handle. So if that's a retainer client of mine, I say, why don't we right now find a good HR partner in New York who's going to make sure that you're doing those trainings that are required, that you know how to handle issues when they come up, instead of waiting until you get the issue. So sometimes it's just being proactive about identifying those partners. So, the magic in the food lies, this is Paul Prudhomme, one of our most famous New Orleans chefs. The magic in the food lies just not in the ingredients, but in the heart of the cook. So I can't give you the recipe. I can give you my gumbo recipe. If anybody wants my gumbo recipe, I can give you that. But not the recipe to fix all of these problems, because it's different for every size employer, for every industry people are in, for every culture that you want to have. It's different. But if you're the cook and it lies in the heart of you, you're going to figure out where your priorities lie. You're going to figure out where your resources are so that you can then put that recipe into play. So the hardest part of making gumbo is, anybody here ever made gumbo? A few? Okay. Well, how do we start making a gumbo? You make the roux. What's in the roux? Oil and flour. Yeah, sometimes butter if you're doing sort of a lighter fish dish. But the roux, why is making roux hard? Takes a while. And what happens if you turn your back on the roux? It burns. And then what do you have to do? Start over, right? So, you know, the piece that I help clients with is really the roux. I know we have so many puns about gumbo this week, but it's really that foundational piece of compliance that you have to get right, because if not, you have to start over. I have well-meaning clients who ran a charter school, actually. This was many years ago. And they were incredible educators. And they were so passionate about coming to New Orleans after Hurricane Katrina and starting this wonderful charter school. But they didn't follow any of the compliance things. And we would say, have you done this? Have you done that? You know, what do you do? You know, what are you doing for these students that need extra help? What are you doing? You know, again, to follow all of the requirements for education in these sort of newish, charter schools were fairly new after Katrina in New Orleans. And while they were excellent educators, they did not stay a charter school in this city for more than 5 years because they got shut down. They got shut down over the stuff that they should have been doing, but didn't do because they were so focused on the passion that they had for the work that they were doing with students. And I know you all have, the same passion, and everybody in your operations has the passion for the product, but if you mess up significantly and you do not attend to the Roux, it's possible that hopefully nobody in here, because y'all are big and well established, but those are the kind of things that can bring your company down. I think even General Honore suggested that. What are we saying? Saddle up Nelson. Everybody remember Nelson? It's hard to remember. I took so many, point of privilege, I took so many things away from General Honore's speech. And if anybody remembers me on the panel, I said, what did I say I was looking forward to? I was looking forward to General Honore because he is spicy and he has only gotten spicier. If I had come up here, talked the way he talked, I might have gotten booed off the stage. But a man of his stature and his age and his experience, it was incredible. So, once you get your Roux right and make sure you don't burn it, you get the creativity to do the fun stuff. You get to do the employee engagement. You get to do the culture stuff. You get to do the things that are probably the things that you got into HR for. Nobody got into HR to deal with the issues that I deal with. And that, again, that is why I don't have employees, because it's not the fun part. The fun part is what you want to spend your time on. So work on these things, get your Roux right, and then you'll be able to work on all the things that make your business great. Thank you so much.